So my name's Rebecca. I clerked for Justice Scalia in 2011 to 2012. And I mean, as Theroux sort of suggested, clerking for a Supreme Court justice is like a truly remarkable experience, and it's humbling every single day, I think, for all of us, for any justice who we work for. It's also substantively really hard. I mean, or at least I found it really hard.
She went to Yale.
Yeah, maybe I was just poorly educated, possible. It was like going to a fourth year of law school, but a much harder law school than Yale. And part of the reason it's hard is you're switching gears between all of these tasks that Theroux described all the time. You might be looking at a cert petition that raises a tricky issue of constitutional law under the Fourth Amendment. Let's say, did the police properly search someone's home, or did they do so in a way that violated the Constitution? And then you could put that down and turn to a merits case, which is like a case that the court has agreed to hear about patent law, which involves scientific issues and what can be patentable. Another thing that the Scalia clerks do in particular, and that more so than any other chambers, and that I frankly was not that familiar with until I got to the court, was all the clerks handle sort of emergency motions that bubble up from the lower courts. But the most common type of emergency motion is a motion that precedes an impending execution. And those, come from the state in which the execution is scheduled. And each justice is assigned a part of the country called a circuit. And Justice Scalia happens to have the Fifth Circuit, which includes Texas. And so the Scalia clerks have to, what the court calls run an execution, weekly, every other week. It depends what kind of a year it is in Texas, but it's a big job. And what happens in those is basically someone on death row, as you guys have all, heard on the news, has probably been on death row for 10, 15, 20 years, and there's a lot of legal proceedings that have happened in that time. And as their execution approaches, they often have a Hail Mary, like one last effort to prove that their conviction was unlawful, or that they're innocent, or something like that. And that Hail Mary will bubble its way up to the court, and the law clerk in the responsible chambers, which is more often than not Justice Scalia's chambers, will review all of the proceedings that have happened, review the petitioner's most recent request, draft up a memo making a recommendation, and the justice will review it and edit it. And then he will, although he has the power to rule on it himself, he never will. He will, for an execution, all of them will refer it to the entire court. So you send out your memo to all other justices, and then the justices all vote and on whether to grant the relief. And the vast majority of the time, the relief is not granted for the simple reason that after 20 years of legal proceedings, it's very hard to have a claim left at this point. This Hail Mary type proceeding is always a long shot as a matter of law. And the Scalia clerk who was running the execution then goes downstairs and signs this piece of paper that basically says, Texas, you're good to go. And you wait there until you get the all clear from Texas, which means we're on the way or it's almost done, and then you go home. And the first time I did this, it was I was almost shocked that I would be entrusted with this type of a job, but it really gives you a perspective on the court system throughout the country, and how these cases that usually wouldn't make their way up to the Supreme Court in normal circumstances do come up on these emergency petitions, and the justices all take them extremely seriously. All these things happen at 9 or 10 at night. The justices are always on the phone at their homes, and all 9 of them, more often than not, depending on the issue, but tend to agree on the outcome. And anyway, that was, I think, that's a not particularly well-known part of the job. So that's another reason that it is a very hard job. So in addition to doing all of this stuff, Justice Scalia, while I was at the court, was writing a book, which is not unusual for him. He's a prolific writer, and he's published several books in the last decade. The book that he was writing while I was there was about the interpretation of legal texts, which is something the Supreme Court has to do all the time, figure out how to read a statute and how to read the Constitution and how to apply it to a particular case. But the book that he's best known for is a book, at least as a justice, is a book that, sort of describes his approach to the law, which is also what, Justice Breyer's book does. And I think one thing Justice Scalia and Justice Breyer really have in common, and there are many, but one thing they have in common is they're teachers, like all of our parents. And they really have this desire to explain to people who are not lawyers, people who are not yet lawyers, what it is that they're doing and how it is that they're doing it, and why you should trust them, They're not just making it up as they go along. And that's what Justice Scalia's book does, just like Justice Breyer's. Justice Scalia, as you guys all know, takes it a slightly different direction. Like Justice Breyer, Justice Scalia is very concerned about the court's democratic legitimacy. And like Justice Breyer, he really believes that a big part of the court's role is to allow people to govern themselves democratically. But they just come at it from different perspectives. Justice Scalia takes that concern and he tries to translate it to a methodology that he uses to approach all cases, which is to say, he's very worried that as he's approaching, a Supreme Court case that raises, as they all do, a difficult, open question, that if he does not have sort of firm principles to guide him, he will wind up just choosing the answer that he thinks is best. Because he, like all of them, they're humans. And they have personal opinions, of course. And so Justice Scalia, at least, his sort of theory for minimizing that risk and for approaching each case in a consistent way is to focus on the text of either the statute that you're looking at, the federal statute, or the Constitution, and to focus on what that text meant or means in an objective sense, rather than to think about what the people who passed it particularly wanted it to mean or what they hoped it would achieve. And that is, certainly not an easy project, and it often requires some historical research into, say, what the Constitution meant to the people who ratified it 227 years ago. But he follows that approach because he wants to, he and Justice Breyer they often do these presentations together, and they have this running joke about, Justice Scalia always says, better to have a theory than no theory at all. They have this joke, you're both at a campsite. Have you heard this? I feel like I'm gonna rock. All right, I'll try it. You're both at camping. Justice Scalia, Justice Breyer are camping, and a bear comes after them, or maybe they're hunting something. They're in the outdoors. They're in the wilderness, and a bear comes after them, and they both start running. And, neither of them are particularly fast runners, but Justice Scalia is I don't have to be a sprinter. I just have to be faster than Justice Breyer. Because the bear only needs one. So Justice Scalia thinks that, his theory of constitutional interpretation, to bring it back to the law, his theory of constitutional interpretation isn't perfect, and it's not easy to apply every time. But at least he's got a theory, and that he tries to make that sort of keep him honest. Because and certainly it's difficult on a case-to-case basis, but he wants something, a sort of stable guidepost to keep him honest. And the reason is that he's very keenly aware that he's not elected, and that he's been appointed for life, and that none of us have any choice, had any choice about him really, and have any choice about whether he stays. And, the way the Supreme Court is now, they end up facing a lot of sort of open questions that seem very politicized to people, understandably. And I think all the justices are worried about seeming legitimate in how they answer those questions and, telling the public that they're not just picking an answer out of thin air or based on their political preferences. And that is at least how he has tried to sort of address that problem in his own jurisprudence. And finally, I would be remiss if I didn't say that he's just an extremely warm, lovely, brilliant man, and it's an honor to be here and talking to you guys. And I feel like it was such a special thing to get to clerk, and then to get to talk about it is just silly. So thank you.